In an age of social media and identity politics, the temptation to reach for the most outrageous term, to vilify and demonize, has become for many irresistible. But if there is a place where words should still matter, where truth should still matter, it is surely a court of law. The applicant has regrettably put before the court a profoundly distorted factual and legal picture. The entirety of its case hinges on a deliberately curated, decontextualized, and manipulative description of the reality of current hostilities. The attempt to weaponize the term genocide against Israel in the present context does more than tell the court a grossly distorted story. And it does more than empty the word of its unique force and special meaning. It subverts the object and purpose of the Convention itself, with ramifications for all states seeking to defend themselves against those who demonstrate total disdain for life and for the law. Representatives of the hostages' families are in this courtroom today, and we acknowledge their presence and their boundless suffering. We know of the brutality of October 7th, not only from the harrowing testimonies of the survivors, the unmistakable proof of carnage and sadism left behind, and the forensic evidence taken at the scene. We know it because the assailants proudly filmed and broadcast their barbarism. The events of that day are all but ignored in the applicant's submissions. The applicant, by its request, seeks to thwart Israel's inherent right to defend itself, to let Hamas not just get away with its murder literally, but render Israel defenseless as Hamas continues to commit it. Remarkably, counsel for the applicant described the suffering in Gaza as unparalleled and unprecedented, as if they are unaware of the utter devastation wrought in wars that have raged just in recent years around the world. Sadly, the civilian suffering in warfare is not unique to Gaza. What is actually unparalleled and unprecedented is the degree to which Hamas has entrenched itself within the civilian population and made Palestinian civilian suffering an integral part of its strategy. Hamas is widely estimated to have over 30,000 fighters and is known to bring minors no older than 15 or 16 into its ranks. They are coming for us. But in South Africa's telling, they have all but disappeared. There are no explosives in mosques and schools and children's bedrooms, no ambulances used to transport fighters, no tunnels and terrorist hubs under sensitive sites, no fighters dressed as civilians, no commandeering of aid trucks, no firing from civilian homes, UN facilities, and even safe zones. There is only Israel acting in Gaza. The key component of genocide, the intention to destroy a people in whole or in part, is totally lacking. What Israel seeks by operating in Gaza is not to destroy a people, but to protect a people, its people.
It is astounding that in yesterday's hearing, Hamas was mentioned only in passing and only in reference to the October 7 massacre in Israel. Listening to the presentation by the applicant, it was as if Israel is operating in Gaza against no armed adversary, but the same Hamas that carried out the October 7 attacks in Israel is the governing authority in Gaza.
The inevitable fatalities and human suffering of any conflict is not of itself a pattern of conduct that plausibly shows genocidal intent. These provisional measures are therefore not within the court's power under Article 41 of the statute. They go well beyond anything required to preserve the specific rights in issue, namely the observance of the Convention in military operations. They seek instead to shut down the military operations themselves.